looking at 25 to life, but y'all are just abandoning these prior convictions and just going on the third-degree felony of DWI?
Yes, sir.
How do we sell that to Mothers Against Drug Driving in this county?
So,
26 CR 410 is called the State of Texas versus Cyrus Sandy. You're Mr. Sandy.
yes, ma'am. I mean, yes, sir. Excuse me.
Generally, they don't mistake me for a girl. That would be, but you had it narrowed between one or the other, and it was a 50-50 shot that you had. You're here with Langston Adams,
Yes,
who is your attorney.
Yes, sir.
And does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, sir.
I see we've got two paragraphs here with an enhancement. Are we passing on the enhancement part?
We are, Judge.
Okay. In summary, this indictment in paragraph 1 alleges that on or about March 2nd, 2025, in Jefferson County, Texas, committed a third-degree felony of fraudulent use or possession of identifying information or items, which is in a number of more than 5 but less than 10 pieces of identifying information. And these are credit card numbers and debit card numbers. And that was without the consent of the people whose names were there on those items and without their permission. So this is a third-degree felony, which means you're looking at no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
Agreement's been reached in your case where you would be pleading guilty, sentenced to 7 years in prison. Then another case, 25 CR 1443, would be dismissed. Is that your understanding of the agreement?
Yes,
I'm
sir.
gonna write a 7 in here too, the numerical 7. Just how do you plead to this charge? Guilty or not guilty?
Yes.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that? Understand it?
Yes, sir.
Discuss it with your attorney? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence
No objection.
and without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Pre-sentence report is waived here.
Yes, sir.
I will follow the agreement and find that you are indeed mentally competent to enter your guilty plea. It is freely and voluntarily made. There is sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this third-degree felony of fraudulent use or possession of identifying information. Items, got to correct the indictment here, the caption. It's got items less than 5 but more than 10, which arithmetically can't happen. Yes, it's good. In the body, it's correct. All right, that's been corrected. There is sufficient evidence supporting this to find you guilty beyond a reasonable doubt of this third-degree felony. I now find you guilty beyond a reasonable doubt of this crime. I am following this agreement. You are hereby sentenced to confinement in the Institutional Division of the Texas Department of Criminal Justice to serve a term of 7 years. And you will, of course, be given credit for all time you have served in accordance with this case. Do you understand what has happened today, sir?
Yes, sir.
All right, that is all.
That's it. Thank you. Appreciate it. Good look, Lord. All right, take it easy. Mr. Falls.
All right, we're back on this 26 CR 605. So go ahead. It was
Right, you know,
set for an announcement. So what's our announcement?
the announcement on Mr. Booth is, he's saying that he is not guilty.
Okay, so we go to trial.
Yes, sir.
That's what we're gonna do. And, Mr. Booth, this one's a second degree felony, aggravated assault with a deadly weapon, so you're looking at no less than no more than 20 years confinement in prison and a fine up to $10,000 can be assessed. Do you understand the punishment range you're looking at?
Yes, sir.
Let me look at one thing.
Texas ones, he can play and his return for call. Which if we're watching, we'll be doing this afternoon, going on, we just have to eat it tomorrow morning, 30 miles. So. That one lady is supposed to be served today. That one says she didn't see if they have her.
Okay, who's the prosecution on that? That one? Yeah, it looks like Mr. Laird. Okay.
Hey, Mom.
Yeah.
Get the NTRP pulled. It's in scanning. I don't have the NTRP that Judge wrote on, that I used to have, where we wrote that Judge found number 5 to be true and revoked him to 4 years. So it was not an agreement.
There's no agreement on that.
There was no agreement.
Okay, that's not fine.
I didn't see anything. And the concern one has is the victim appearing, and it's obvious the defendant doesn't think she's going to show up. I mean, we've done this enough. This is a homeless group that we're dealing with, and he's rolling the dice on she won't show up. So we're just gonna set it for trial and see what happens. That's all we can do. But you can't have any contact with the victim nor anyone on your behalf. If that happened and we caught that, that would be a new crime. And then you would be subject to more prosecution. So let the system play out without interfering.
Yes, sir.
That is all.
Thank
I
you,
have
Judge.
a Sean Craig dismissal. Do I sign that?
Thank you, Judge.
And Nathaniel Clark,
Oh, you're legal.
right there first, and then come back.
Clark, please raise your right hand.
Did you visit with Mr. Winter?
Do you swear or affirm to tell the truth, and nothing but the truth, so help you God? Okay, I need to get your thumbprint. Right thumbprint.
Is it
Place
true?
flat on that box right there.
It's supposed to.
You can have one more time. One more time. Right outside the box.
We're all those are going to not be
Perfect, thank you. Step in front of the judge.
half marathons. The Vatican, my favorite. Plus the music and food was off the chain.
So it's been awesome.
When I went there, I went to Avery Island, which is a visit.
Okay. Explain to me what we're doing here. He's an habitual felon, right?
Correct, Judge.
Okay, so he's looking at 25 to life, but y'all are just abandoning his prior convictions and just going on the third degree felony of
Correct.
DWI?
Yes, sir.
How do we sell that to Mothers Against Drug Driving in this county?
Well, the reason why I made the decision is because of the age of his priors and the facts and circumstances of this scenario. In addition to his particular age, I felt like justice would be best served with this agreement, Judge. And if they have any complaints, they can visit with me about it. And I'll go into detail.
I don't like games. Okay. Too much crying and weeping that goes on in this room because of intoxication. It wears over 20 years. And here, I mean, it's just not your first. This is your third DWI. Plus, you got an illegal possession of drugs conviction in 97, then a felony conviction, aggravated battery in 99. But it's a 2012 first conviction out of Wichita Parish, the DWI. And then after that, in 2015, another conviction, and then this one. I mean, the thing is these are 4 prior convictions that you've had, and they're all serious. 2 of them are felonies, but now this one constitutes a a third felony conviction. Anyway. No, we're gonna go to trial. I'm not gonna handle it this way. We'll let the jurors decide what's appropriate under his circumstances. Okay, thank you.
Yes, it's changing.
We'll set it for trial. All right, we got Jamal Mishaw.
And we'll
It's in the caption, so it's not part of the body, but it's still wrong with it. Okay, 7 years confinement. And the other case will be dismissed. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
Is there any restitution?
I don't believe so, Judge, but let me check on the process.
And that's where this courtroom takes a serious turn. The judge wasn't simply looking at one DWI. He was looking at a long history of dangerous offenses and asking whether this deal truly served justice. In the end, the case was sent to ward trial, while another defendant walked away with a 7-year prison sentence for identity theft. Two very different outcomes, but one courtroom reminder: past decisions can have a major impact on what happens next.